I think, upstairs again, just like last time.
And where will the award, what do those here?
Here.
All right. So
Manuela's putting a script together. I will dash off when this gets started to help with that. Yeah.
watch this. I'm really excited. It's good it's set this way because I won't disturb them. We don't have any Sarah buttons.
Well, we do. We have a rebuttal, but no Sarah.
So far, I mean, I was concerned. I mean, walking back, the weather was kind of more like what I was concerned about. It's a bit windier. But organization has been great.
That's true. I did get a call from Patricia.
Quiet them down and get ready to go.
Give him,
I'll give him 2 minutes or whatever.
give him another minute. They're sort of talking for a moment. We're watching the news.
I'm going to give them a heads up that we're going to start. Ladies and gentlemen, we'll be starting in about 2 minutes, so please come in and sit down if you wish to watch the round. So, welcome to the 2018 FDI Moot final here at Stockholm University, and viewers, I think, across the world, in both hemispheres. My co-director, Chris Gibson, will introduce our esteemed arbitral tribunal, and then we will get started.
Good afternoon, and let me just first of all give you a brief agenda for the afternoon. We're going to be having the final right now, and that will be followed by an awards ceremony, which will also take place in this room, and then that's followed by a brief reception, which will be in the foyer, which is up on the second level in the back of this room, where we were at the beginning of the competition. And so, what I'm going to do is I'm going to introduce the panel. I'll ask them to stand for a moment. And starting on my right, your left, we have James Hope, who is a partner and head of Vinga's, a dispute resolution group in Stockholm. He hosted the arbitrators and the team coaches the other evening, and we thank him for that. He's a dual-qualified Swedish advocate and English solicitor advocate with over 20 years of experience in dispute resolution, including practice in London and here in Sweden. He acts both as counsel and as arbitrator in international arbitrations, both here in Sweden and abroad. To his left, you're in the middle, we have the chair of the panel, Lauren Aguiar, who's a partner in the New York office of Skadden Arps. Of course, Skadden Arps has been the global sponsor of this competition since we founded it in 2008. We're grateful that she flew over from New York to join us here this afternoon and chair our final procedure. Lauren is a very experienced counsel representing both U.S. and international clients in litigation and arbitration involving a very broad range of areas and disputes, including one close to my heart, which is intellectual property. And then finally, On the left to your right is Christopher Loff, who co-chairs the dispute resolution practice, and he's also a member of the firm's industry group for energy, natural resources, infrastructure, construction at Mannheimer Swartling. He is specialized in dispute resolution and works on all stages of the dispute, from early assessment to claims letters to settlement negotiations, appearing both before Swedish courts and in Swedish international arbitration. So we're very honored and pleased to have such an experienced group of arbitrators to hear our two teams today. Please join me in a round of brief applause for our panel. And now Chris will briefly introduce the names of the two teams.
That's easy. We have Team Klaestad against Team Broms. They've made their way through several hard days and hard matches to this point, and at the end there'll just be one, right? So with that, I'll turn it over to Lauren.
Welcome to the two teams, and congratulations for having made it to this point. We've introduced ourselves to you. Would you like to each introduce yourselves to us and to the rest of the folks here?
Good afternoon. My name is Igor Kirillov, and I'll represent Team Broms, and I'll speak on the procedural issues, the issues of jurisdiction and admissibility of claimants' claims.
Thank you.
Good afternoon. My name is Aglaya Melnik, and I will address the merits of the primary claim and the admissibility of respondent's counterclaim.
Great. Welcome.
Good afternoon, members of the tribunal and everyone. My name is Edina Rosena, and I will be addressing the procedural issues on behalf of the claimant Fenascadia Limited.
Great.
And good afternoon, members of the tribunal. My name is Pia Ruggieri, and I will be addressing the merits of the present dispute on behalf of the claimant and also the inadmissibility of the respondent's counterclaims. Thank you.
Excellent. Welcome to both of the teams. And we want to thank both the claimant and the respondent for your excellent written submissions. We have both of your memorials. We also have the order of arguments and your agreed timing. We will be keeping time, but we would ask that both of the teams also monitor yourselves and keep your time as well. So why don't we begin? I think we're going to start with the respondent on jurisdiction. Please go ahead.
Again, good afternoon, members of the tribunal. My name is Igor Kirillov, and together with my co-counsel, we represent Respondent, the Republic of Kronos. And I'll first address you on the two issues of procedural nature, jurisdiction and admissibility of claimants' claims. Members of the tribunal, the BAT is a great instrument of protection, but it's limited, and it only protects the investors which satisfy the criteria enumerated in the BAT. And we are here today because claimant doesn't satisfy this criteria. To that, we have two procedural objections. First, this tribunal doesn't have jurisdiction because claimant is not a Ticadian investor under the BAT. And second, in any case, claimant's claims are not admissible because it has already submitted the same dispute before the national court. Now, turning to my first submission, the BAT protects investors, but not just any investors, investors of the other contracting party. And so to determine the scope of the BAT, we should first look at the definition of this investor of the other contracting party. And to that, may I invite the tribunal to look at page 39 of the case file.
We're there.
So on page 39, we have part of Article 1, and at the bottom of the page, we have paragraph 4, which defines the term investor of a contracting party, and it reads, I quote, "The investor of a contracting party means a contracting party or a person or an enterprise of a contracting party." Now, claimant may argue that this definition contains an incorporation test. However, they see that the word incorporation is simply isn't there. We concede that the term enterprise of a contracting party does not provide an express guidance to any particular test. But that is why we have Article 31 of the Vienna Convention of the Law of Treaties. And this article permits us to look at the ordinary meaning, at the object and purpose of the treaty, and then Article 32, as a supplementary means, permits us to look at the preparatory work. And we submit that if we look at those factors, if we look at the full picture, the conclusion should be clear, that parties wanted the investor to have real economic activities in the home state to be protected under the BAT.
But counsel, while you're talking about looking at things as a whole, would you agree with us that this provision in the BIT is actually fairly broad, this definition of investor?
Yes, Madam Arbitrator. However, we would consider that the very broad definition doesn't mean that we should apply just any test. It just means that we should interpret it, and under Article 31, that is the criteria that we should apply. So, as for the ordinary meaning, for example, Merriam-Webster Dictionary defines enterprise as a unit of economic activity. Similarly, different other dictionaries, for example, Oxford Dictionary, put stress on the economic aspect of the investor. So essentially, an enterprise of a contracting party means that to become such an enterprise, you need to have a unit of economic activity in the home state. And we see here that claimant effectively shut down its operations in Ticadia. So it doesn't have that unit of economic activity anymore. But of course, this alone is not sufficient to reach the conclusion. So we should also look at the object and purpose of the treaty to confirm our reasoning.
Counsel, if I could ask you, is it your submission that the claimant started off being an enterprise of the contracting party and then lost that status over time?
Exactly, Mr. Arbitrator. It is our submission that, of course, at the time of incorporation, before it shut down its facilities in Ticadia, it was an enterprise of Ticadia, but it's not an enterprise of Ticadia anymore.
And what exactly was it that made the shift of status?
Mr. Arbitrator, to that, may I just guide you to page 33 of the case file. So, if we read at the bottom of the page, paragraph 12, that's the uncontested facts, it states that in 2010, claimant decided to transfer and concentrate almost all its mining activities and resources in Kronos. And then there is a clarification, effectively shut down its mining operations in Ticadia. And that is why we submit that there is no economic unit of activity in Ticadia.
But Counsel, if you then read the next page, it goes on and says nonetheless, and its business management formalities, again, are carried on in Ticadia. What do you say about that?
Mr. Arbitrator, we indeed recognize that most of the meetings of the board are carried out in Ticadia. We can also recognize that some of the taxes are paid in Ticadia. However, the test is not just corporate formalities. Corporate formalities are necessary consequence of incorporation. What we rather should look at, and this is what where preambles helps, one of the objects is to stimulate a mutually beneficial economic activity. And the Alps Finance Tribunal, Alps Finance versus Slovakia Tribunal, which interpreted the preamble, although the text of the BAT was different, the preamble stated the same, and it explained the rationale, which was very clear. When there is such a purpose, the parties want to...
Just on this one, I mean, the investment, the alleged investment here is economic activity in Corona. So how are you saying that there is a need for supplemental activity in the investor's state? So we should not view whether this is an investment based on the activity in this investment, but based on what other activity the investor has.
Mr. Arbitrator, of course, under the investment, to satisfy that there is an investment, we should look only at the investment in Kronos. And we do not contest that there was initially a foreign investment. But what we contest is that there was a foreign investor in the sense of Article 1.4 of the BAT. Because what parties wanted is that to become a foreign investor, you should not only invest in the other country, you should also retain some of the activity in the first country, because they want mutually beneficial business activity.
But picking up on that then, let's focus on the private equity shop that owns your LLC. Is it not true that several of the members of that private equity shop are from Ticadia, and how do you address that argument?
Madam Arbitrator, that's actually an alternative submission. I would actually brief into that. If this tribunal is not convinced by the real economic activity criteria, we would suggest that it would apply a control criteria, which is this is all about. And indeed, we do not contest that 65% of shares is held by Ticadian fund, and we are even ready to concede that we shouldn't look after that, but we should just look at the Ticadian fund. But the problem here is with the standard, because as explained in Thunderbird versus Mexico case, where the tribunal considered a similar situation of a minority shareholder, it stated that indeed ownership is a prima facie evidence of control, but ownership is not control. Control is actually a constant pattern of influence on the company's decision. And here, indeed, it's uncontested by the parties that it's Cronian shareholders that had this constant pattern of influence on the decisions of the company. And just to give you one example of that influence, just to give you a timeline, we know that the shares were acquired in 2012, and from this very year, for the last 5 years, it was made so that the majority of the board elected, one of the primary decisions by the shareholders, the majority is the Cronian nationals. And to reiterate again, this was not connected with the movement of activities, because the movement of activities happened 4 years before the shares were actually acquired. And that is why we submit that under the control test, we indeed satisfy claimant does not satisfy the control test, and it's not Tikadian national even under the control test.
What would lead us to apply the control test, because it's not in the BIT?
We agree, Mr. Arbitrator, that it's not in the BAT. Our submission is that real economic activities is in the BAT. But should the tribunal disagree, then as permitted by Article 31 of the Vienna Convention, we should look into the international law as a supplementary means of interpretation, and we are prepared that claimant may assume that it's incorporation that is default or widely accepted rule. But all the investment tribunal that actually applied this test, for example, Tokyo Stockholm versus Ukraine, Rompetrol versus Romania, in all the BATs there, the incorporation test was actually expressly included. And so, for example, in Tokyo Stockholm, the Ukraine-Lithuania BAT stated that to become an investor, you only need to be established under the laws of Lithuanian Republic. We do not have that here. And on the contrary, the tribunals which dealt with the BATs that do not contain the test, for example, Sedelmaier versus Russia decision of 1998, it stated that there is a tendency to apply control tests to the definition of national, because the country usually wants to know who the national is, and then it applied the control test.
Could I just ask you to go back to the definition that we have, which is enterprise of the contracting state, and I wonder about the ordinary meaning of the word of.
Mr. Arbitrator, the ordinary meaning of the word of is, of course, to provide some link, admittedly the link, but the problem with the corporations is that it's very easy to move, and thus we agree that the doctrine, the practice are struggling to determine what link should be sufficient. There are a plethora of tests which can apply, but we submit that that is why the word of by itself does not give us guidance. However, the word enterprise should give us guidance to that.
But the word of could give us guidance. We could just interpret it naturally to say that it's sufficient, that it's an enterprise of the contracting state that is incorporated there.
Mr. Arbitrator, our submission is that where the parties want to apply incorporation test or to have a renvoi to national law, they expressly include it. So, for example, in Chinese BAT, there is frequently as established under the laws of BAT. And as a supplementary argument, may I guide you to preparatory works, which are situated on page 61 of the case file. So on page 61, we have paragraph 4, which starts with the word "the tribunal." And it reads, the fourth paragraph, "The tribunal notes that the Tikadian model defines investor as follows. Investor means any individual or a company incorporated under the laws of the contracting party." And we know that initially, Tikadia sent this model BAT to Kronos, but then in the course of negotiations, they considered both definitions, and they not only replaced the neutral corporate law term company with the term enterprise, but they also excluded the word incorporation. So at the very least, we should not consider the test that the parties have excluded. But that is why we, under our first submission, we ask you to find that this tribunal doesn't have jurisdiction.
I have one last question for you before you move on to the fork in the road. There's some evidence in the record that your president made a public statement that the LLC in this case is, quote, a foreign entity. And while I can sympathize with not always liking the statements of one's president in public, How do you address that issue here?
Madam Arbitrator, first of all, as stated in Saluka versus Czech Republic, the statements of politicians are the least that the investor can rely upon. But in any case, the problem is that if we can interpret this provision under the VCLT, it is true that we can consider the practice of the parties, but only the practice of the parties which relies to the relevant instrument, and that is why the definition is given for the purposes of the BAT. However, there is no indication in paragraph 53 that President was talking about the BAT, simple as it is. And to move on to my second submission, in any case, the claimant's claims are not admissible because it has already submitted the same dispute to the national court. So to determine whether the same dispute was submitted, we first should look at what were the disputes and what is the relevant criteria. So just to state clearly what were the disputes before the two courts. In the national court, the claimant asked for provisional relief to suspend the decree, but it also asked for the final relief to declare the decree unconstitutional. And we know that the effect of that declaration under the national law would be to set aside the decree and return the investment. And before this tribunal, it's asking the compensation for this investment. So how do we decide whether these are the same or not? First of all, we need to look at the relevant provision. And to that, may I invite you to look at page 44 of the case file.
Okay.
So on page 44, we have Article 11, and paragraph 3 provides for the fork in the road clause, and the only condition to the submission of disputes to the arbitral tribunal is, I quote, that the national or company concerned has not submitted the dispute for resolution. So this BAT uses the term dispute as opposed to the term claim, a more narrow term which, for example, is used in ASEAN Model Investment Agreement. And the term dispute was defined by Lucchetti versus Peru arbitration, not just a claim, but a situation which gives rise to different disagreements on fact and on law. And that is why, as defined by United Nations report on the investor-state dispute settlement, the purpose of the fork of the road clause is to accumulate different claims which relate to the same dispute before one fora. It's not to avoid parallel proceedings, because for that we have res judicata, we have lis pendens doctrines. And that is why, as applied by H&H versus Egypt tribunal, which considered the similar clause, which also relied on the dispute, the word of the dispute, it stated that at the very least, the claim should have the same fundamental basis. And as explained by Chevron versus Ecuador case, second submission, what is the fundamental basis? It's the origin and aim of the claim. And what are the origin and the aim here? So let's imagine a car was stolen, your car was stolen. That is the origin of the dispute. And then you have two options. You want to obtain a compensation. You can either get the car back, or you can ask for money as an equivalent. That would be the same aim. And here we have the same situation, because the origin was the same, the expropriation of claimant's assets by the decree, by one and the same decree. And then claimant tried two different ways to obtain this compensation. In national court, it applied to setting aside the decree, and if the decree were to be set aside, then first the concession agreement would be restored, and the license would be restored, so there would be no dispute. And then
I might have missed you here, but are you arguing the fundamental basis test? Or the
yes, Mr. Arbitrator.
And what leads us to that test?
Mr. Arbitrator, we are submitting the term dispute actually points that in this case we should apply the fundamental basis test, as opposed to other BATs which use the term claim. And H&H tribunal, which dealt with this provision, the exactly same worded provision, submitted that we should apply the fundamental basis test in these cases. And in this case, the aim, the origin and the aim that was explained in Chevron versus Ecuador are the same. Just return back to the aim. Either you get a reparation in kind, or either you get the reparation in damages, but essentially it's once and for all reparation. And that is why we claim that these claims are inadmissible. And to conclude, we would like...
I'm sorry, I don't want to cut you off mid-flow, but am I right in thinking that the claim before the national court doesn't include a claim for compensation and doesn't have the aim of obtaining compensation?
Right, Mr. Arbitrator. Indeed, it doesn't include the claim for compensation. But first of all, this is not needed to trigger the fork in the road clause because it is our submission that it's not the claim which triggers, but the submission of the dispute. So if any claim pertaining to this dispute is submitted, the fork is triggered.
So
but
you say it's sufficient that any claim relating to the dispute would be submitted? Any claim at all? That seems a bit wide, isn't it?
Mr. Arbitrator, of course, we should be reasonable and the factual connection should be manifest. But in this case, if the decree would be set aside, then all the provisions of the decree would be null and void, and first, the investment would return back, the license would be restored, the seizure of lender would be lifted. So essentially, we don't see that essentially here the disputes, we see that essentially the disputes here are one and the same, because the aim would be the same. And we ask this tribunal to find that claimant's claims are inadmissible and that this tribunal lacks jurisdiction. Thank you.
Claimant?
Yes. Good afternoon once again, members of the tribunal. Members of the tribunal, on a desperate attempt to prevent this case from being heard, the respondent is introducing inexistent restrictions into the VAT. It is time to put an end to respondent's imagination. During my submission, I will address both issues brought up by counsel for respondent and in the same order for the benefit of this tribunal. And thus, I will argue, first, that this tribunal has jurisdiction over the present dispute. And second, that the claimant's claims are admissible under the VAT. Starting with my first submission, contrary to the respondent's allegations, this tribunal has jurisdiction over the present dispute because, as I will demonstrate, the claimant qualifies as a national from Tcailia. To prove this point, I will address three arguments in the same order raised by counsel for respondent. First, that the claimant is a national from Tcailia because it was incorporated under the Tcailian law and it has its seat in Tcailia. Second, that the real economic activity test proposed by counsel for respondent should not be applied by this tribunal, because indeed we would reach an impracticable solution. And third, that the control test also proposed by counsel for respondent shouldn't either be addressed by this tribunal. But even if this tribunal decides to apply this last test, still it will find that the claimant is a national from Tcailia. Starting with my first point, members of the tribunal, the present VAT is not a common VAT. As correctly pointed out by counsel for respondent, this VAT lacks any reference or any criteria as to what is the criteria that this tribunal should use to determine the nationality of the investor. Thus, we agree with counsel for respondent that as both states are signatories of the Vienna Convention on the Law of Treaties, this one should be used on Article 31 to interpret the term investor. However, we disagree with the interpretation made by counsel for respondent. Counsel for respondent stated, and I quote, that under Article 31, the parties wanted the investor to have real economic activities in order to define nationality. However, members of the tribunal, in the present case, the parties were unusually broad in defining the term investor. Indeed, they didn't provide for a particular test for the tribunal to apply to determine nationality.
But do we know why that is? Do we have any information in the record regarding the negotiation of this BIT and why that is the case?
Madam Arbitrator, we do not have any information as to the reason. What we have from the drafting history, even though it is Article 32 and should be addressed after Article 31, what we have is precisely that the parties had a model providing the incorporation theory, but didn't use it. But it is not that the parties introduced another test. The parties were unusually broad, and they didn't provide for any test. We cannot suppose that this was just accidental. The parties had a meaning for that. And we're facing today, this tribunal is facing, that it still needs to determine whether the claimant is or not a national from Tcailia, even though there is no specific test. And for this,
Counsellor, if I could just ask you, you're relying then on the ordinary meaning test under Article 31 of the Vienna Convention, are you?
Mr. Arbitrator, we are not relying on the ordinary meaning of any word, because the word enterprise, as proposed by counsel for respondent, actually cannot be interpreted, or the ordinary meaning of the word enterprise wouldn't provide this tribunal with any particular test. Indeed, counsel for respondent use the ordinary meaning of the word enterprise to allege that there is an economic connotation of this word, and thus that the economic activities should be considered. However, this isn't accurate. First of all, because the ordinary meaning of the word enterprise isn't unanimous. For instance, the Black's Law Dictionary equalized it to company, corporations. The parties, even in Article 11, used the word company. And this is even shown because other BITs use the word enterprise and adopt the incorporation theory. For instance, in 1995, which was the year that the Ticaria Kronos BIT was signed, another...
Here comes another one.
Sorry.
This is what they call a hot bench at home, but you're doing right.
Just to understand what you said, are you saying that you're not using Article 31? So you're saying that this language does not carry any ordinary meaning? Because in extension, that means that we have nothing then, no?
Mr. Arbitrator, I am relying on Article 31, but not on the ordinary meaning. Article 31 reads that a treaty shall be interpreted in good faith, in accordance with the ordinary meaning given to the terms of the treaty in their context and in light of its object and purpose. I will be relying on the object and purpose. But first, as for Mr. Arbitrator's question, the thing here is that the ordinary meaning of the word enterprise wouldn't provide for this tribunal with a test to apply. The ordinary meaning of the word enterprise is not disputed here. It is common knowledge what an enterprise is, a company, an organization, a project. The problem here with this clause is precisely that this tribunal doesn't have a test to apply. We don't know what is the nationality of that enterprise.
But why do we need a test if the language, assuming that the language in its ordinary meaning was clear?
Precisely, Mr. Arbitrator, because an enterprise doesn't necessarily have to have an economic connotation. This tribunal cannot infer that merely from the word enterprise, the real economic activity test should be applied. An enterprise, as the parties equalize it, is a company. And thus, by applying Article 31, because this tribunal, as stated, still needs to determine whether the claimant is or not a company from Ticaria, by applying Article 31, a good faith interpretation in accordance with the object and purpose of the present VAT, which is to promote investment and promote economic cooperation, will require this tribunal not to set restrictions where the parties did not. Indeed, as stated in the Tokyo Stockholm versus Ukraine case, in application of Article 31, it is not for tribunals to impose limits on the scopes of VATs not found in the text.
But counsel, of course, Prosper Weil doesn't agree with that in that same case and is going rather further in applying that same test. What do you say about that?
Mr. Arbitrator, what counsel for respondent, if I understood correctly, stated was that this case relied on the VAT relevant to that case. There was a specific clause of incorporation theory. However, what we're stating here is not that this tribunal should restrict solely to the incorporation theory, but rather that the parties didn't provide for a test, and thus, if the object and purpose of the VAT is to promote investment, what this tribunal should do is not restrict the scope of the term investor to one particular test. And this was stated in the Tokyo Stockholm, that a tribunal shouldn't impose limits on the scope not stated by the parties themselves. And for this, so to provide guidance to this tribunal, BATs and case law have mainly resorted to two tests, the incorporation test and the seat of the company test. Both of these tests, under both of these tests, the claimant is a national from Ticaria. It is an undisputed fact that the claimant was incorporated under Ticarian laws. And, as I will now demonstrate, the claimant has its seat in Ticaria. Thus, this tribunal should not deny protection under the VAT to the claimant once the claimant has complied, not only with one of these tests, but with both of them.
And how do you address the argument that your company has essentially ceded its management, though, to Cronians?
Madam Arbitrator, precisely under the seat of the company test, the nationality of a company lies where the effective center of administration or the management of the company is. And precisely, if we follow the criteria set in Alts Finance versus Slovak Republic, which was quoted by counsel for respondent, this tribunal will find that indeed the effective center of administration of the claimant is in Ticaria and not in Kronos. And this is due to the following facts. First, all of the claimant's business formalities are carried out in Tikedia. Second, most of the meetings of the board of directors are carried out in Tikedia, thus meaning that the decisions are taken in Tikedia. Third, the claimant CEO resides in Tikedia. Fourth, as it arises from the record, whenever the claimant wanted to contract or contact with third persons, the claimant would provide with his phone, fax, and address of the Tikadian office. And lastly, the claimant complies with its corporate tax obligations in Tikedia. Now, counsel for respondent stated, and I quote, that these are corporate formalities and are a consequence of the incorporation theory. However, members of the tribunal, it is not a consequence of the incorporation theory that the board of directors decides to meet currently or normally in a certain state. Neither is it a consequence of the incorporation theory where taxes are paid or where the CEO resides. All of these factors were specifically addressed in the Alps Finance versus Slovak Republic. And this one addressed not the seat of the company as a formalistic approach and consequence of the incorporation, but rather of where, in reality, the management of the company was. Now,
and counsel, you're saying what was said against you a moment ago is that we shouldn't be looking at that. We should be looking instead at the real economic activities, and we were told that the fundamental change happened during the course of the time. What do you say in answer to that? Do you say that's irrelevant, or what do you say?
Mr. Arbitrator, precisely, counsel for respondent stated that the real economic activity of the claimant should be considered in order to address nationality. However, it is our submission that this fact, the economic activities of the claimant, shouldn't be considered to determine nationality. And this is due to the following reasons. First of all, this test does not provide, or shouldn't be addressed by this tribunal, as a test by its own to define nationality. And indeed, in VITs, this test was never addressed as a sole criteria to determine nationality. For instance, in the Alps Finance versus Slovak Republic, the test provided for determining nationality was that the company should be incorporated into a certain state, it should have its seat, and its real economic link. And this, members of the tribunal, has a reason of its own. That it is that if a tribunal applies the real economic activity test as the unique test to determine nationality, it could arise, and in most cases would, to an impracticable result or inconclusive results. And this is precisely what happens in the present case. Members of the tribunal, nationality must be considered by this tribunal at the time when the arbitration claim was filed. As stated in SIAC versus Montenegro, the condition of jurisdiction must be fulfilled at the moment when the parties' consent to arbitration is perfected. This is at the moment when the arbitration claim was filed. In the present case, the arbitration claim was filed on the 10th of November of 2017. Now, 7 months before that date, in April 2017, the claimant completely shut down all of its operations in in Kronos. And as correctly pointed out by the respondent, the claimant didn't have operations in Tikedia either, economic business activities in Tikedia. And so, at the time of the filing of the arbitration, the claimant didn't have economic operations at all, neither in Kronos nor in Tikedia. And thus, if this tribunal applies the approach proposed by counsel for respondent, it will find, or it will arrive to an absurd result, that is, that the claimant has no nationality at all. And that is why we propose the other tests, either the seat of the company or the incorporation test. Now, counsel for respondent also relied in the control test. I will now demonstrate that the control test shouldn't be addressed by this tribunal.
But let me interrupt you there for a second. In today's world, how realistic or practical is it really to apply the seat of the company or the incorporation test when sometimes companies are incorporated in one place, they're managed by another, their CEO lives somewhere else, their board of directors is spread all over the world, and they may be owned by a holding company that is very complex in its structure? Can you address that practical question?
Madam Arbitrator, I see your concern, and it is true. That is something that happens today a day. However, this doesn't mean that all of that needs to have a negative connotation. The fact of adopting an incorporation test or a seat of the company test is something that it's in a majority done in every BAT. And it is a policy of the parties that when adopting this test, they want to provide shelter or they want to provide protection under the BATs to these type of companies also. Indeed, some authors have stated that actually treaty shopping or shell companies or the hypothesis proposed by Madam Chair is indeed something that liberalizes investment law. So there is no need to see it with a negative connotation, but rather that it answers to a policy of the parties to the BAT. And now addressing, if there are no further questions, the control test proposed by Counsel for Respondent. I will first demonstrate why this one shouldn't be applied by this tribunal, and second, that even if this tribunal decides to apply it contrary to the respondent's allegations, it will find that the claimant is a national from Tikedia. First of all, the control test, as stated in the Tokyo Stock Exchange versus Ukraine case, should be applied as an exceptional measure. And this actually has been used or addressed by tribunals because tribunals have only applied it either when VATs specifically allow for a tribunal to lift the corporate veil or either in cases of fraud. Now, and this has a reason of its own, and is reasonable because indeed a company is a separate person from that of its shareholders. It has its own rights and obligations, and this treatment should be given under normal circumstances. In the present case, the BAT does not allow this tribunal to lift the corporate veil, and nor is this tribunal facing a case of fraud, because indeed Fennoscadia was incorporated 2 years, the VAT was even signed. Now, still, if this tribunal decides to apply the control test, it will find that the claimant indeed is a national from Tikedia. And this is because, as already pointed out by Counsel for Respondent, only 35 of the shares were owned by Croatian nationals. The other 65 was owned by a Tikedian fund. Now, the respondent based on de facto control or effective control and stated that these 35% of the shares that were owned by Croatian nationals, that these shareholders, and I quote, have considerable influence over the decisions of management of the company. However, members of the tribunal, if you may follow me to page 56 of the record. 56.
Okay.
This is procedure order number 2, and on paragraph 2, on the last line, line 1525, it reads, the voting right held by each shareholder is in proportion to the shares held by them. And thus, members of the tribunal, the influence that these shareholders may have starts and ends at the willingness and the vote of the majority of the shareholders.
But Counsel, isn't this a bit unreal? I mean, I'm thinking of the arguments that are often put against this sort of line, and the argument is that we have to look at what is a genuine international investment. I'm quoting, of course, from Prosper Vowell in the Toklis case. And taking a step back, are we really thinking, should we think this is a genuine international investment here? Should we not actually explore that issue? You tell us basically to shut that out.
Mr. Arbitrator, first of all, we respectfully submit that this tribunal should rely on the BAT, which doesn't provide for this real investment, if there was in reality an international investment, if it is or not. But in any case, this tribunal is facing an international investment case, because indeed the claimant was incorporated in Tikedia, the claimant has its seat in Tikedia, the claimant has no operations elsewhere, and the claimant is controlled by a majority of Tikedian shareholders, and thus this tribunal couldn't conclude otherwise.
And therefore, but I mean, the issue really against you is that we have to look at the reality behind control. You say we should look at the percentage of who gets to vote and the corporate law aspects. Can we really ignore the reality? The reality seems to be what the other side is saying against you.
Mr. Arbitrator, we submit that the reality here shows that indeed it is controlled by the Tikedian fund. And this is precisely because no matter the influence that these 35% of the shareholders may have, this is influence on decisions, but not the taking of decisions. The taking of decisions renders in the Tikedian fund.
I notice that time is quite short. Would you like to use that remaining time to address the other issues that were argued?
Yes, Madam Arbitrator. I will quickly address the second submission. If I may have one additional minute to
You may, and then I think we'll give another minute to the other side to use as they think appropriate.
Thank you. So quickly, contrary to the respondent's allegations, the claimant claim is admissible under this tribunal. Now, the respondent relied on the fundamental basis test. Under this test, two things were considered by tribunals to know whether the fork in the road provision can be triggered or not. First, whether the fundamental cause of the claim is the same, and second, whether the effects sought are the same. For the first element, the fundamental cause, tribunals have relied on the normative source. And in the present case, the normative source of the two claims submitted by the claimant is not the same. On the claim initiated before the national courts, the normative source was the Cronian domestic law. And in the one initiated before this arbitral tribunal, the legal basis was the VAT, as the respondent breached Article 7 of the VAT. As for the second element, this is the effects sought. The tribunals have relied on the relief sought by the two claims. Now, in the claim initiated before the national courts, what my client sought was to set aside the effects of the decree. And in the claim initiated before this arbitral tribunal, the effects sought are different. My client is seeking for monetary compensation for the indirect expropriation of the respondent. And here I will end my submission. Thank you.
Thank you. A rebuttal?
I just had one question,
Yes,
if I
of
may, and
course.
this doesn't include your time.
Thank you.
But the other side's main argument, I think, on that point was that we distinguish claim and dispute. And I wonder if you have any comments on that issue. They rely on the fact that dispute is a much wider word.
Can you rephrase your question, Mr. Arbitrator? I'm sorry.
The other side's argument against you on that is that here, in this particular wording in the BAT, that there's a question of dispute, and dispute is wider than the word claim. And I just wondered if you have any comments on that particular issue.
Mr. Arbitrator, the disputes on the present cases are different. One dispute is the one presented at the national courts, and the other dispute is the one presented at this tribunal. And under Article 11, under the fork in the road contained in this clause, the investment disputes are different, and thus the fork in the road was not triggered.
Rebuttal?
Thank you, members of the tribunal. Two quick points. The first is that claimant's point of departure was a statement that an enterprise cannot have economic connotation, while actually claimant misquoted Black's Law Dictionary, and the widely accepted definition is that it provides a venture for business purposes. So we cannot agree with claimant that there is no clear meaning what an enterprise means. And as to the point of the real seat test, it is telling that claimant addressed the point we didn't raise. But even if this tribunal decides to apply the real seat test and follow the Alps Finance versus Slovakia test, the meetings of the board are actually not sufficient. There should be a certain number of the employees, and then there should be a physical locations where general expenses or overhead costs are incurred for the maintenance. Clearly, meetings of the board and the place of living of the CEO does not satisfy this test. Thank you.
Thank you. Sir, rebuttal?
Yes. Members of the tribunal, 2 points on sub-rebuttal. First of all, as for counsel for respondent's allegation that there is no clear, that claimant said that there was no real meaning, no clear meaning on the term enterprise, actually the parties themselves equalized the term enterprise to the term companies. So regardless of what dictionary says, the BAT is quite clear. And second, as for the Alps Finance case, this tribunal should know that in the Alps Finance versus Slovak Republic, the clause providing for nationality actually had 3 tests: the Incorporation Test, the seat of the company test, and required additional economic activity. So all that was addressed there is even with a higher threshold than the one addressed. Thank you.
All right, then, why don't we move on to the merits? And I understand the claimant will begin, and you have 19 minutes.
That's right. Good afternoon, once again, members of the tribunal. As mentioned, my name is Pia Ruggeri, and I will be addressing the remaining 2 issues on behalf of the claimant, which are, first, that the respondent unlawfully expropriated the claimant's investment, and second, that the responder's counterclaims are inadmissible in these proceedings. Members of the tribunal, the people of Kronos are facing the consequences of environmental pollution, an issue that truly concerns us all. Unfortunately, the respondent's reaction to this situation not only failed to reverse the situation in Kronos, but was also impulsive. Rather than negotiating viable alternatives with the claimant, the respondent decided to abruptly expropriate an 80-year concession, leaving the claimant empty-handed. Turning to my first issue, the respondent, by issuing a presidential decree, unlawfully expropriated the claimant's investment. And this is because the decree, first, prohibits the exploitation of Lindoro in Kronos. Second, it terminates all of the government's concessions and licenses for the exploitation of this mineral. And lastly, the decree confiscates all of the already mined Lindoro in the claimant's facilities. Now, the BAT provides for 4 requirements in order for an expropriation to be lawful. They are that the expropriation must be done for a public purpose. Second, in accordance with the due process of law. Third, in a non-discriminatory manner. And fourth, on payment of due compensation. These 4 requirements are cumulative, so it is enough for the claimant to prove that the respondent did not comply with one of those requirements in order to find that the respondent is liable for unlawful expropriation. In the present case, we are not contesting that the respondent may have acted motivated by a concern to protect its environment and its people, hence complying with a public purpose. However, we do contest the way in which those measures were taken, and that is why we will address the due process of law requirement, the non-discrimination requirements, and the payment of due compensation requirement. So first, turning to the due process of law. In this context, it means that the investor should have been given a reasonable opportunity to comment and negotiate alternatives to expropriation with the respondent. The decree entered into force with immediate effect and was issued without any warning to the claimant. Furthermore, the study in which that decree is based was also conducted without any possibility for the claimant to say a word about those findings. In the present case, the due process was not complied with by the respondent.
Well, how do you address the study itself? I mean, you said you were not given an opportunity to comment on the study, but the results of the study are fairly alarming. How do you address that?
Madam Arbitrator, we understand that the results of the study are alarming, and that is why we are not contesting the pursuance of a legitimate public purpose by the government. However, the claimant should have been given a chance to at least try to conduct other studies or contradict the findings of the respondent. And that is precisely what the due process of law tries to give the parties a fair treatment of both parties in order to assure that the measures taken by the government in this case are in compliance with this requirement.
Has your company since done that? And has it been able to come forward with any evidence that contradicts the study?
Madam Arbitrator, my client was not able to conduct other studies because as the expropriation entered into force just 5 days after the issuance of the decree and the claimant was prohibited from extracting the Lindoro, and hence any study conducted just on the Lindoro already extracted was totally useless for this arbitration. Now, moving on to the non-discriminatory requirements imposed by the BAT. It is respondent's contention that the decree itself is a target measure, and this is for various reasons. First, because there are other mining operations taking out in the respondent's territory that did not get inspected nor expropriated. Second, that the same year that the new government of the respondent took office, it decided to fund a study focused solely on the exploitation of Lindoro. And third, that after the issuance of the decree, the president made a statement that was just 3 paragraphs long. In those 3 paragraphs, the name Fennoscadia Limited is mentioned 4 times, which probably shows that the respondent was more worried about Fennoscadia Limited itself rather than by the exploitation. Now, regarding the requirement of payment of compensation, it is an undisputed fact that no compensation was paid to my client. And this is mainly because the decree by itself states that all of the contracts, licenses, and concessions of the government are to be terminated with no compensation owed by the Cronian government. The only way for the respondent to override this requirement was to either frame its actions under the Police Powers Doctrine or under Article 10 of the BAT, which provides for general exceptions. However, members of the tribunal, the present situation cannot be framed under the scope of any of these two provisions. So first, addressing the police powers doctrine. We recognize that states do have a power to regulate their internal affairs in accordance to their sovereign powers. However, those powers have limits, and one of them is that they must comply with the principle of proportionality. As assessed by the tribunal in TechMed versus Mexico, what must be analyzed is the treatment given to the investor that is legally protected and the proportion to the public purpose that they are aiming. Members of the tribunal, in the present case, the respondent took unbalanced measures led by its impulsiveness. We have, on the one hand, yes, Mr. Arbitrator.
How does these criteria, which you now discuss under due compensation, how do they relate to the due process criterion, where you also laid out certain requirements with respect to proportionality and your right to suggest other methods?
Mr. Arbitrator, the requirement of due process was assessed when referring to Article 7 of the BAT, which contains the expropriation clause. Now, when addressing the requirement of compensation, we are stating that the only way for the respondent to escape from this obligation to compensate the investor was to either to say that this is not an expropriation and that its actions fall under the police powers doctrine. The police powers doctrine has its limits, being one of them, of those limits, that the principle of proportionality must be met. And we are now assessing that this proportionality was not complied. Yes.
Counsel, I realise we're bombarding you with questions, but is it not the case that the measures taken were reasonable and proportionate given the great harm that was found in the study? Are you suggesting that the government should have waited in some way and therefore that more harm could have been incurred during that period?
Yes.
They needed to act promptly, didn't they?
Mr. Arbitrator, members of the tribunal, we are not stating that the respondent should have waited and then just take measures, because obviously if the claimant is then found liable for the environmental damages, of course the damages to the respondent territories would have been much worse. We are suggesting for other measures that the respondent could have taken in order to achieve this exact same purpose. For instance, a suspension of the activities for a while in order to allow the claimant and the respondent to work jointly towards working on another solution rather than expropriation, and also to let the respondent be sure that their scientific studies were proved. Yes, Mr. Arbitrator.
I'm just intrigued by this because I think it goes to the same point again. Are you now discussing the criterion under the due compensation or the criterion under due process?
Mr.
I think the arguments seem to be the same.
And then perhaps is the answer that some of these just overlap, these factors?
Members of the tribunal, we are still under the ways in which the respondent may address the no compensation of the no payment of compensation, and of course this tribunal will have to assess all of the requirements that I am laying out in a cumulative manner. However, we are separating this analysis for the benefit of this tribunal and stating that first, if the police powers doctrine were to be applied, which probably the respondent will ask this tribunal, that the principle of proportionality was not met. And this is because we have on the one hand that the expropriation cost the claimant damages valued in no less than $450 million and led it on the verge of filing for bankruptcy. And we have on the other hand that the result for the respondent has not been as significant. And this is because 2 years have elapsed since the expropriation of the investment, and the situation in the Kronos environment and health has not significantly improved. Now, the other defense that the respondent may address in order not to pay compensation to my client is to frame its actions under Article 10 of the BAT. If you could please follow me to page 43 of the record. We can find the Article 10, which has general exceptions.
Were there?
Article 10.1 reads that for the purpose of this agreement, each of the contracting parties may adopt or enforce a measure necessary. The key word here is that the measure must be necessary. And as both parties are signatories, as already stated, of the Vienna Convention of the Law of Treaties, we are going to assess the ordinary meaning of the word necessary. It is understood that necessary means that is something that is needed to be done to achieve a particular purpose. And also tribunals, when facing cases where states have addressed the necessary requirements, have understood that in order for necessity to be complied, there must not be other reasonable alternative. In this case, and as I was already stating when addressing a question from Mr. Arbitrator, we suggest that the respondent may have acted by suspending the activities of the respondent. And this is not an innovative solution. Case law has already assessed situations like this. For instance, the tribunal in Windstream versus Canada has stated that the Canada's government's actions to suspend the activities of the investor in order to further assess if the studies conducted will arrive to a conclusive result on the environmental impacts of the exploitation, was the correct way to act for the government, because this did not amount to an expropriation of the investment, but rather allowed both parties to work jointly towards another solution, and not to resort to the most drastic measure that the respondent had, which was to expropriate the claimant's investment. Now,
Sorry, but here, what respondent did was not really to expropriate, it was to suspend the license. You still have all your assets and operation left there.
allow me to disagree, Mr. Arbitrator, as the decree itself has various measures that amount to an expropriation. First, it prohibits the exploitation of Lindor and Kronos. Then it is true that it suspends or revokes all of the government's concessions and licenses, and it also confiscated the already mined mineral in the claimant's facilities. With these measures, what the respondent did was to prevent the investor from managing, controlling, or enjoying its investment, which is the parameter to assess indirect expropriation. Now, it is clear that the respondent's actions can only be framed under Article 7 of the BAT, which has the expropriation clause, and that the differences that the respondent may assess regarding Article 10 with the general exceptions or the police powers doctrine are also not complied with by the respondent. But on top of effecting an expropriation of the claimant, the respondent decided to file a counterclaim for the alleged damages caused to the environment by the claimant. However, and now, as a second submission, I will demonstrate that the respondent's counterclaims are not admissible.
Just before you do that, I wonder if you could comment on the fact that the agreement that was entered into, the concession agreement, in clause 2.2, the company commits to comply with good practices for the sustainable exploitation of Lindora. They seem to have, your client seems to have breached its obligation. Is there really an expropriation of the investment in those circumstances where they've breached their own agreement?
Mr. Arbitrator, the claimant did not breach that clause because the respondent inspected the claimant twice every 2 years since the beginning of the exploitation and found the claimant to be in full compliance with its environmental obligations.
What if we were to find that there was a breach?
Mr. Arbitrator, in that case, apart from an expropriation, there would have been a breach of contract. However, as addressed, the actions of the respondent do not comply with the 4 requirements addressed by Article 7 of the BAT, and also the decree itself amounts to a substantial deprivation of the claimant of its investment. Hence, expropriation has taken place.
Thank you.
Now, assessing the counterclaim raised by the respondent in this arbitration. First, counterclaims are not admissible in these proceedings, and this is because the parties have not provided consent to arbitrate counterclaims. The dispute resolution clause refers that only the national or company concerned may choose the fora in which to pursue an arbitration. The only reference to counterclaims can be found on Article 11.5, if the tribunal could follow me to page 45 of the record.
We're on page 45.
Right. In clause 5, it reads that in any proceeding involving an investment dispute, a contracting party shall not assert as a defense, counterclaim, right of set-off, or otherwise that the national or company concerned has received or will receive, pursuant to an insurance or guarantee contract, indemnification or other compensation for all or part of its alleged damages. The respondent will probably rely on this clause to state that the parties have consented to arbitrate counterclaims.
Right, but then how do you address, let's look in the record at page 48, section 7, paragraph 7,
Yes.
dispute resolution. And it says that any dispute arising directly out of this agreement including its termination, shall be submitted to the courts of the Republic of Kronos, which hold exclusive jurisdiction. Can you address how that relates to the provision that you just pointed out?
Madam Arbitrator, precisely. We submit that if the respondent were to bring a claim against the claimant, it should have done it under this clause posed in the concession agreement, which provides for exclusive jurisdiction of the national courts of Kronos. And this is because, when submitting the counterclaim, the respondent based on Article 9.2 of the BAT. However, this is an argument by labeling, because when removing that tag, we find that Article 9.2 does not impose any obligation to investors, but rather to the contracting parties, namely Kronos and Ticaria. What Article 9.2 does is to state that the contracting parties in their regulatory measures must abide by principles of environmental protection, and that in those regulations they must incorporate the polluter pays principle.
Is the dispute resolution provision a double-edged sword for you then? And doesn't that present a problem to your jurisdictional argument that your colleague argued earlier?
Madam Arbitrator, what we are stating is that the respondent based his claim on the BAT in order to be protected under on the dispute resolution clause of the BAT, which is Article 11, and be able to resort to arbitration, when what the respondent, should have done was base his claims on the concession agreement. Yes, Mr. Arbitrator.
We also have Article 9 of the SEC rules providing that respondent may submit counterclaims with its answer to the request for arbitration. Do you have any comments on that?
Mr. Arbitrator, it is true that the SEC rules provide for counterclaims in arbitration. However, as understood by tribunals, for instance, in Oxus versus Uzbekistan, and precisely AMTO versus Ukraine, which was decided under the SEC rules, the counterclaims were rejected because where no consent was given in the BAT, and the BAT is more restricted than the arbitration rules, the tribunals should take that into consideration, because the arbitration rules provide for procedural requirements for the tribunal, but do not put consent where the parties have not. And that is why we submit that even though the SEC rules do provide for a provision of counterclaims, they do not amount to consent of the parties, because in the BAT itself, the parties decided not to consent to counterclaims. Now, to wrap up this submission, members of the tribunal, we have first that the respondent expropriated the claimant's investment, and on top of that, it decided to file a counterclaim that should have been done under the concession agreement, because there is where this tribunal finds the obligation of investors. And there, as pointed out by Madam Arbitrator, the jurisdiction is the national courts of Kronos and not this arbitration. So, in conclusion, the claimant respectfully requests this tribunal, first, to find that it has jurisdiction over the present dispute. Second, that the claimant's claims are admissible under this tribunal. Third, that the respondent is liable for unlawfully expropriating the claimant's investment for an amount of $450 million. And lastly, to find that the respondent's counterclaims are inadmissible in these proceedings. Thank you.
Thank you. Respondent on the merits. You have 21 minutes.
Madam Arbitrator, 21, I believe.
21? Yes. Okay.
Members of the tribunal, the opposing counsel, good evening. My name is Aglaya Melnik, and I appear as counsel for the Republic of Kronos, respondent in the present proceedings. In the following 21 minutes, I will first demonstrate that the presidential decree was a legitimate exercise of Kronos' police powers and should not be compensated for, and secondly, that the respondent's counterclaim is admissible. Members of the tribunal, Finoscadia's portrayal of facts seems to exclusively focus on the decree's impact on Finoscadia, overlooking the gravity of events that led to the adoption of the decree by Kronos, an underdeveloped state in the midst of environmental crisis. Members of the tribunal, and to this we make two submissions. First, that as stated, the decree indeed was a legitimate regulatory measure that is not to be compensated for. And secondly, and in any event, it would likewise qualify as a general exception under Article 10 of the BIT. Members of the tribunal, indeed, the police powers exception, as internationally recognized principle, for instance, by tribunals in Quiborix versus Bolivia, allows a state, and just to clarify, this is specifically an exception from compensation obligation with an expropriation context. It allows a state to implement measures in pursuit of public purpose in a proportionate, non-discriminatory manner and in respect of due process of law. We will address the points raised by the opposing counsel in turn, starting with the due process, discrimination, and proportionality. But for the sake of clarity, before I proceed, we would like to just simply state that criteria under the police powers and Article 10 overlap. Article 10, as the opposing counsel referred to, was a measure that is necessary, for instance, for protection of human health. While investment tribunals have not analyzed in detail what this test is about, we concede that indeed it is not self-judging, it has its limits. Article 20 of the GATT, under the WTO, which is worded almost identically to our Article 10, states that in cases such as Brazil tires or European Communities asbestos, for a measure to be necessary, first, there also should be a balance between importance of the goal and restrictive nature of the measure, and also no less severe available alternatives. So in that, we submit criteria overlap, and we will demonstrate this in a minute.
They overlap, but did I understand you correctly that your defense is based solely on the police powers?
Mr. Arbitrator, it is, but should the tribunal decide that Article 10 is the lex specialis and that it provides, just Article 10 provides an exception for a state, we submit that it would also inevitably qualify under Article 10, should it first qualify as a police powers exception. So starting with the allegations made pertaining to the lack of due process, we understand that the opposing counsel stated that Finoscheria was not provided reasonable opportunity to comment on the decree and the study prior to their adoption. So first, members of the tribunal, we submit that while Cronin Environmental Act came out in June 2015, the data by the Environmental Ministry of the respondent raising the first alarming concerns about increase of toxic waste in the Rare River came out in October 2015. In 6 months, and there was no reaction from the claimant. In 6 months, a study comes out that directly implicates claimant in the pollution of the environment, and yet there were no responses for 4 months. Eventually, the decree was adopted, and we submit that Finoscheria had sufficient time to demonstrate at least that it was not at fault, because under the Cronin Environmental Act, it is sufficient for an operator to demonstrate that in order not to be liable. And in this respect, we submit till the day of the present proceedings, investor was unable to come up with any evidence contrary to the study. So we submit that it would be unreasonable to invoke that, of them to invoke the fact that they were deprived of the right to comment. Members of the tribunal, the same logic would apply to the study, in fact, because 4 months were sufficient to at least demonstrate that the operator was not at fault. But in any event, according to tribunals such as Quiborgs and ADC versus Hungary, the due process of law is fundamentally satisfied whenever investor has the opportunity to challenge the measure before the national courts. And we know that the Cronian judicial system provided for remedies to challenge the decree, which in fact the investor resorted to. And just for the, yes, Mr. Arbitrator?
No, sorry.
Sorry. And just for the sake of clarity, we also understand that claimant made a point that there was no reasonable advance notice. However, we would like to point out that the decree was announced on 7 September 2016, yet it only was bound to enter into force in 5 days after. And on the very next day after the announcement, claimant filed to the Cronian courts to contest the decree. And on this basis, we submit that this, in fact, was the reasonable advance notice of which they took advantage.
There's been an attack. There's been an attack on the independence of the study undertaken, and I was wondering if you could tell the tribunal which of the factors that you laid out do you believe the independence goes to?
Madam Arbitrator, first and foremost, we submit that bad faith is not to be presumed according to tribunals in Kimtura versus Canada and others. It is indeed a very high threshold. We submit that no bad faith is to be presumed either on behalf of the researchers or the state that funded the study. And primary evidence to that would be also that till this very day, we have no contrary evidence, contrary scientific researches that would contradict the findings of the decree. And on this basis, we submit that the due process of law requirement was complied with. Turning to the issue of alleged discrimination, members of the tribunal, we submit that the decree did not discriminate against Finoskadia. According to tribunals such as Saluka versus Czech Republic, discrimination fundamentally occurs whenever there is differential treatment of investors or companies under similar circumstances that lacks objective justification. And even if members of the tribunal were deemed other operators, other miners in Kronos that also use open pit mining techniques, appropriate comparators to Finoskadia, that is, under similar circumstances.
Councillor, I'm sorry to interrupt your flow, but do we not see now that there's now a suggestion by the government to start mining again? And might we not take from all of that that they're now doing that with their own people and together with another country, that there does appear to be an element of discrimination?
Mr. Arbitrator, to this we submit first and foremost that the information pertaining to alleged joint venture has not been officially confirmed and remains a rumor. And in any event, in order to find discrimination as such, there should be, at the point of when the measure was taken, an existing comparator, that is, an existing real company against which a state could discriminate, which was not the case at hand. And the objective justification, members of the tribunal, was present because the study, at least in relation to the link between the mining of the Lindoro and the impact on the environment, found a conclusive, decisive causal link. And we submit that with respect to other operators, there has been no proven threat emanating from them.
On your point about there being a proven link, if we look at page 51 of the record,
Yes, Madam Arbitrator.
line 1415, it actually says with regard to microencephaly that a longer sampling window is required to conclusively confirm that the exploitation of the mineral has triggered that. So can you address the difference then between the cardiovascular disease and the microencephaly?
Of course, Madam Arbitrator. So, well, we have to make two distinctions. So this is true that with respect to the mining of the Lindoro and its impact on human health, the link is yet to be conclusively established. We nevertheless submit that circumstantial evidence is overwhelmingly against Finoskadia because we also know from the facts of the case that both of those diseases were virtually non-existent in Kronos prior to advent of Finoskadia to Kronos. But even if the tribunal were not satisfied, we would submit that at least given that we have that the link between mining of the Lindoro and the pollution of the Rare River has on the other hand been found conclusive, that is in fact the very first line, members of the tribunal of the same page 51, which states that the contamination of the Rare River is undoubtedly a direct consequence of exploitation of Lindoro. And on this basis, we submit that the measure still was a non-discriminatory one. We would like to also turn to the issue of proportionality raised by the opposing counsel. We do concur that according to tribunals such as TechMed versus Mexico and PL Holdings versus Poland, indeed, a measure is proportionate. First, whenever there is a balance between the importance of the goal that it pursues and the impact that it has on the investor, and also when there are no less severe alternatives. Members of the tribunal, we submit that the waste from extraction of rare earth metals should not be underestimated, not only because it is highly toxic, but because in cases with most other rare earth metals, contains radioactive isotopes, and therefore mismanagement of such waste can lead to grave results, and therefore the state was reasonable. But as to the alternatives, and specifically the suspension, members of the tribunal, we submit that even though in hindsight today it may seem like a remedy, in truth it was an ephemeral remedy, precisely because, let us take this logic further and imagine the type of risk that the respondent would be accepting to take should it allow Finoskadia. So the agreement could look as something that their respondent and claimant reach an agreement, and that claimant promises to come up with alternative ways to sustainably mine Lindoro and decontaminate the river. But respondent could never again have this assurance that should another legislation come out, should another scientific data concerning their operations come out, that claimant would act duly and react and cooperate. And in this respect, we submit that Mr. Arbitrator.
I'm just concerned about the economic realities here, because if we look again at page 51 of the record, we see that what the study is suggesting is there should have been a decontamination of the waters of the Rio River, which was estimated to amount to $75 million US or so. This claim, of course, is for a lot more money. What has happened here is that it was, as a result of the decree, claimant has lost very much more money than that, and it surely would have been possible to suspend, carry out that decontamination, and then try to start again in a proper way.
Mr. Arbitrator, well, first and foremost, 2 points. We do not know how much they lost. We know that they are claiming for $150 million, but this is to be assessed in the quantum stage. We do not know for certain that they lost more than $75 million, depending on the evaluation. But Mr. Arbitrator, to address the aspect of going on as usual, should the decontamination take place, this is precisely the point that we are trying to make, that even if investor agreed that it would decontaminate and then research the new alternative ways to mine Lindoro, which in fact would be the only logical reason to suspend, the respondent state could no longer have the trust necessary for an investor to conduct such hazardous activities that are...
We're going back this way.
And you're only relying on one study, aren't you?
Mr. Arbitrator, well, we submit that, first of all, the study can also be supplemented by 2 facts that do not seem to be contested by other parties. That is that Lindoro extraction emits graspel, and that other 10 top-tier universities found a connection between graspel in the water and the impact on human health.
Is it a problem for you that only 80 infants were examined? That seems like a very small sample.
Mr. Arbitrator, we submit that, well, in any event, the sample, we do not know exactly the population of Kronos around the Lindoro mine site, but we submit that it is still a very telling result, even given that the pool was not a very wide one. Mr. Arbitrator.
Yeah, I have a question relating to this, and I think to what extent have respondent considered other measures? Because I think in order to determine that something is proportionate, that a certain measure is proportionate, you must have some kind of assessment of the alternatives.
Mr. Arbitrator, we submit that, first and foremost, alternatives should be reasonably available. That is to say, investor cannot give any hypothetical example and state that the respondent should have considered this. But what we submit is that the only alternative to deal with the pollution was first to terminate its source, and we know that there is no certainty as per how graspel exactly is released through.
But you do know that there might be other sources, other mines, which are not covered by this decree.
Mr. Arbitrator, to this we submit that while claimant has not been able to adduce evidence to that other mine has released graspel, we can also rely on circumstantial evidence, such as that we know that the Lindoro was discovered in the process of looking for more ore deposits in Kronos in 2000s, from which we can derive that ore, for example, and iron have been extracted for a certain period of time. And we also know that those diseases, cardiovascular microcephaly, were non-existent still prior to 2010 in Kronos. And on this basis, we submit that there's been no evidence to reasonably believe that other operators emit graspel, although we do concede that ideally, of course, respondent state should examine all other operators. It is just that given the urgency of the situation, it acted reasonably in reacting first to data and looking at the operator who posed the threat.
Do you need to explore that now, after the facts, in order to make sure that you're not acting in a discriminatory way?
Mr. Arbitrator, we submit that while in general respondents should inspect other operators, still what mattered in order not to find or not to find discrimination is the exact point in time when the respondent made this decision to adopt the decree. And at this point in time, there was only certainty as per Lindoro emitting Graspel and not other operators. And they previously also raised no other concerns with their operations. Members of the tribunal, and on this basis, we would like to request you to find the decree as a legitimate exercise of Cronus's police powers, or in any event, a legitimate measure that seeks to protect human health. Turning now to our second submission, concerning counterclaim raised by the respondent. We understand that essentially the opposing side contests that there was consent, in other words, that this tribunal has jurisdiction to hear the counterclaim. Now, members of the tribunal, our counterclaim is simple. The claimant should compensate for the environmental damage that it caused in Kronos. And we submit that, first and foremost, for the sake of clarity, we base our counterclaim not on any operative clause of the BIT, rather on Kronos's domestic legislation, Cronian Environmental Act, precisely because Article 11 of the BIT, that is the jurisdictional clause, the arbitration clause of this treaty, is worded broadly enough to allow a state to bring counterclaims on the basis of its domestic jurisdiction. I would like to invite the tribunal to turn to page 44 of the case file. Members of the tribunal, so Article 11.1 on that page reads that an investment dispute is a dispute between a contracting party and an investor of the other contracting party arising out or related to an investment agreement between contracting party and such person. We submit that, first and foremost, this is the clause that would allow us to bring a counterclaim under KEA, because KEA is related to that investment agreement. For the sake of clarity, we do not rely on the concession agreement. We know that Article 7 of the concession agreement, as pointed out by Madam Arbitrator, has a jurisdiction clause that defers to exclusive jurisdiction on Kronos's domestic courts, but it pertains to disputes directly arising out of concession agreement.
May I ask, do you see any problems with arguing that this gives us jurisdiction, whilst at the same time arguing that claimant is not an investor under this BIT?
Mr. Arbitrator, we submit that we could only introduce the tribunal would only have jurisdiction over counterclaims if the investment of claimant is deemed an investment. Otherwise, if the tribunal deems that it does not have jurisdiction over the investment dispute, the primary claim, Kronos will go to its domestic courts to bring this claim. So just to elaborate on how the tribunal has jurisdiction specifically is that the dispute that Cronian Environmental Act generated, its breach in fact, is related to investment agreement precisely because Cronian Environmental Act governed investors' activities under the concession, that is the mining of the Lindoro. And with this respect, we submit that this tribunal has jurisdiction. And moreover, members of the tribunal, there has been consent of the investor to arbitrate such disputes. I would like to invite you to turn to page 3 of the case file, simply to confirm that. Members of the tribunal, paragraph 2 states that by submitting this request to arbitration, claimant accepts the standing offer made by respondent to arbitrate investment disputes with claimant's investors enshrined in Article 11 of the BIT. That is to say, investor consented to a standing offer made by states when they concluded this arbitration clause. So from the point of full consent, with no exceptions as to counterclaims, the only source of interpretation for this tribunal's jurisdiction is Article 11.1. We therefore submit that tribunal has jurisdiction, and the second requirement, members of the tribunal, I seem to have 15 seconds left. May I request 1 additional minute to conclude?
Why don't you wrap up as quickly as you can?
So members of the tribunal, simply the second criterion that has to be satisfied is sufficient factual connection between primary claim and counterclaim. And as stated by the Urbarza versus Argentina recent decision that considered counterclaims, connection is sufficient whenever counterclaim arises from not only from the same investment, but also from the same concession, which is precisely the case at hand, and we therefore would like to request this tribunal to find counterclaim admissible. Thank you.
Thank you. Rebuttal?
Yes, please. Members of the tribunal, 2 points on rebuttal. First, that counsel for respondent stated that after the issuance of the Korean Environmental Act, there was no reaction from the claimant. However, after the issuance of the Korean Environmental Act, the respondent inspected the claimant and found that even under those stringent environmental obligations, the claimant was in full compliance of those obligations. Hence, no reaction was expected from the claimant. And also, when addressing the ADC versus Hungary case to assess due process, counsel for respondent missed the point, as it also states that some basic legal mechanisms, such as a reasonable and fair opportunity to comment on the proposed measures, is to be expected for the investors. And lastly, that it stated that the only way for the respondent to act was to attack the source of contamination. The source of contamination is Graspel and not Lindoro. 2 years have elapsed and no other regulatory measures to attack Graspel have been taken. Thank you.
Thank you. 1 minute, sir, rebuttal.
Madam Representative Justice, I was looking for a quote from ADC. Members of the tribunal, we have 2 points. First, we do understand that, of course, respondents state with relation to inspection should have researched the dangers of Graspel earlier, but we would like to point out that as soon as the ministry was able to do it, it publicly revealed the very next month the data that there was increase in toxic substances. So as a prudent investor, Finoskeria should have reacted. And members of the tribunal, ADC versus Hungary tribunal stated explicitly that the possibility to comment before a measure and reasonable advance notices are just ways with which respondent can comply with due process. But what fundamentally matters, and if not violation is found, is that there is a functioning judicial system that can provide for investors' grievances. And with this, we'd like to conclude. Thank you.
Thank you very much. I think this will conclude the hearing. Extremely well done, very high level at advocacy. Thank you all very much. I think I understand that. Why don't we give them a round of applause, yeah?
As Madam Chair just said, this remarkable hearing is now over. And the points of order, first we're going to ask the tribunal to briefly excuse themselves so that they can deliberate to arrive at a decision which, given the hearing that we just witnessed, I think will probably be a very difficult task. But before they do, please join me in giving another round of applause to our tribunal for their excellent examination of the problem. It's easier for them to leave than for all of us to leave for a few moments. Okay, and while they are deliberating, again, I'm sure it's going to be a very difficult decision, we're going to start with some of the awards, but of course not the award for this final. We can ask the teams now. Again, excellent, wonderful job. It was a remarkable hearing. I enjoyed it. You can now relax and join the rest of your teams, and we'll start with the awards. Thank you. As we turn to the awards and why we still have your attention, I want to add a few different points of thanks. First of all, and importantly, I want all of you to join us in thanking Stockholm University, and of course, we use the SEC rules this year, so the Stockholm Chamber of Commerce. Please join me in thanking our hosts and the SEC, the rules. We also, as you look to my left, yes, you can see all of the local sponsors. all of these folks that came together to make this a possibility, this competition. It happens every year in different places around the world. It's a pretty remarkable group of sponsors that we have here in Sweden. And so, again, join me for all of the local sponsors that helped to make this a possibility. Now, all of you, as you went through this competition, there were 3 people sitting in front of you, those arbitrators who come from different points here in Sweden and from around the world. They contribute their time and their expense to come and hear your arguments. So I want you to, again, give another round of applause, both to the arbitrators and also to the memorial judges who judged all your memorials. Finally, you're probably sitting in a row, and someone on that row might be your coach. Those are the folks that took you through this process and helped you. So all of the team coaches have put in significant time and effort, so you should shake their hand, give them a round of applause as well. Yeah. I'm going to introduce very briefly Tim Nelson. Some of you might have appeared before. Arbitrator Nelson. Tim Nelson is partner with Skadden Arps, which, as I mentioned earlier, is our global sponsor, has been with us since 2008. And Tim, if you want to say a word or two, you're welcome to come up here. At least the mic it works pretty well, or you can, yeah.
I have a little sign here saying position the microphone as shown. So you didn't know that. One of the things I get to do every year is, of course, to thank the organizers of this event. And Skadden has been privileged to be associated with this event, but it has been a success because of the tireless efforts of a number of organizers, but I single out 3, of course, Professor Chris Gibson, Christian Campbell, who you've met, and Manuela Inez Vedam, who is very familiar, I hope, to all of you, and her organizational skills are instrumental in this proceeding. I'd like also to pay particular tribute to our hosts at Stockholm University and the Law School, Sandra Fagerlund and Patricia Shaughnessy. I think both of them deserve special mention. I'm told I have to instill in you an enthusiasm for the next venue. Let me just say this venue is terrific, and this hall is one of the most, and I've been to almost every final in this competition for the last over 10 years now. This is one of the most magnificent venues one could wish for in Stockholm. And I had the privilege this morning of visiting the Nobel Museum, and I learned all about Alfred Nobel. And if you know anything about his personal life, he was what the Americans would call a piece of work. He was euphemistically called a restless soul. He invented a number of explosives. He was very good working with nitroglycerin, although it exploded and killed his brother. It didn't kill him. He invented gelignite and dynamite and ballistite, and lots of very useful inventions. He became interested in peace, apparently, when he woke up one morning and read his own obituary, a mistaken obituary that said, "The Merchant of Death has died." And he took this to heart, and he thought, well, how do I improve upon the Merchant of Death image? I'll get involved with world peace. Okay, so he gets talking to peaceniks and to people who really want to stop war, and he said, I have an idea. I will build another form of explosive, but this time it'll be big enough to destroy entire armies, and that way you won't have war anymore. And he was the sort of person who probably could have done that. He had that kind of ingenuity. But he was talked out of that, first on the grounds that it probably wouldn't be conceived as a step towards world peace, and also, really, if you're concerned about that Merchant of Death image, not good. So Plan B, which he implemented through his living will, was to create an annual prize for those who contributed to mankind, humankind, peace and scientific inquiry, hence the Nobel Prizes. So my moral for that is that foreign direct investment arbitration, I think we should also understand, emerged in the same era as the Nobel Prize and was also a Plan B. It was a Plan B because at that time, economic trade was seen as an implement of state power, and so an investment dispute was resolved through force. Send in the Marines, the gunboat, the invading army to resolve your economic disputes with the other party. And the arbitration system we have today was designed as a substitute, a peaceful substitute. Well, there's two things that go with that, which are both very essential to what you do. One, as I say, it's a form of peaceful, non-violent resolution of what can be very high-stakes disputes. But the other, which tracks into what Nobel did, and I'm delighted that the problem this year dealt with, is that it's fact-based. And fact-based inquiry, truth-based inquiry, is under siege in this world, including by the president of the host state in this hypothetical problem, but maybe from other world leaders as well. And I was delighted that this moot question this year called upon the participants to engage in science-based and fact-based inquiry as to whether the measures in question were justified. So thank you to the problem drafters in particular. And every year, the people who need to be acknowledged in this moot are not just the organisers, sponsors, coaches, teams, hosts, but also the problem drafters. And I'd also throw in a word for the arbitrators who come every year, and not just for the competitors, but for their long-suffering families. So thank you all. I have to say something about the next venue. You all have in your packets that the next venue is Miami. To those of my generation, that would be self-advertising. We had a television show on TV, well, actually, that's tautology, but we had a television show called Miami Vice, and in the late 80s, it was, especially amongst the younger gentlemen, regarded as one of the coolest things one could be associated with, Crockett and Stubbs. And so Miami would be a no-brainer in terms of places you would want to go. Nowadays, not so much. I don't think, unless you're a YouTube aficionado, I don't think that works, but it is the land. Miami remains the land of South Beach, Art Deco, Cuban food, flamingos, and alligator farms. And if one of those appeals to you, you should sign up. If you can tell your friends about the experiences, I hope positive, you've had in this mood, sign them up. If you yourself have the capability of competing again, sign up. Maintain the enthusiasm and tell your friends and get involved. It's a fantastic event, and once more, thank you to the organizers and thank you for the opportunity of being associated with this.
For all of you who just went through this competition, you are now FDI Moot alumni. So congratulations for that. And building on what Tim just said, we invite you also to come and act as arbitrators, or you can become involved as memorial judges, or you can help draft future FDI Moot problems by joining our case drafting committee. So there's ways to stay involved. I was really pleased this year to see so many of our former team members, participants, who are now traveling to act as arbitrators, to be on the other side of the table, as it were. What's going to happen now is we're going to give you a few minutes just to relax while we get together the awards. I'm waiting for Chris and Manuela to come back with that. So as soon as they're back, then we'll be able to start the awards ceremony. I see two of our panelists are back, and so we'll be having the answer to that final question as well. So just a few moments. this is great, yeah. Why?
Because we want to take photos.
Oh, I see. So then should we put things on that table and then we'll, yeah, and then we'll. Place to do this.
Yes.
It's remarkable.
I'm a little bit in two minds about whether to use a slideshow or not, because you did it in such a rush. I'm not sure if the timings are right, and if you're going to reveal something that you don't want to reveal.
Oh, whether you have the animation on, I understand.
Yeah.
If you want to take it off for a second and test, you can either do that. There you go.
I'm sorry, this one's what?
You can do those all at the same time.
Yeah, we could. I was just wanting to get the. I mean, I don't want to. I want them to come up, but I don't want to let them know already how they did. Oh, shoot.
Oh. I don't know how that happened. It's on there again. Can you disconnect it from the HDMI cord for a while if you want to test that? Chris? It's on again. It's on again. I would pull out the HDMI. It's not going to behave. I don't know. Usually it's here. Simple. So yeah, be aware it's on the screen.
Well, I may pull it out again. Just in the end slot.
It's up there.
Something's happened. Show's cancelled. Okay, we do it without the slides.
Okay.
Do we? I'm sorry, but the PowerPoint doesn't work, so we're going to have to cancel the awards ceremony. Okay, I think we're ready to start now. You've waited more than long enough to find out some results. I'd like to ask the following teams to come forward. We're going to start with written submissions and claimant memorials. So could I please have Team Mosler, Team Schwebel, and Team Taurus come forward? Yourself and your university.
Hi, we're Team Mosler. We are from Gujarat National Law University, India. Thank you.
Hello, we are Team Taurus from West Bengal National University of Juridical Sciences, India.
Turn around and let him get a photo of you. With the, yes, come back and get your photo as well. They're so quick, so young and quick. And let me ask again, Team Schwebel. Is Team Schwebel here? All right.
And so the number one claimant memorial went to Team Schwebel, National Law University, Jodhpur.
So now we're coming to the ranking of the respondent memorials. I'm not going to ask Team Schwebel to come up because they're not here. Could I please have Team Badawi and Team Taurus? You're Badawi, right? Please introduce yourselves.
Hello everyone, Team Badawi, St. Petersburg State University.
That's for the second ranked respondent memorial.
And the best respondent memorial was again Team Taurus.
Particularly dressed for the occasion.
You can remind them who you are again since you did it twice.
We are Team Taurus from the West Bengal National University of Juridical Sciences, Calcutta.
Right, right. So now we come to the ranking of the advocates, and every year we ask 10 of the best advocates to come forward. When I read your name, please come up here and line up. Of course, one of you is the best advocate of all, but we'll figure that out eventually. Okay, so please, Jessica Allen. Vera Bikova. Ayana Banerjee. Sam DeLong. Igor Kirillov. Karen Odidika. Aglaya Melnik. Kartik Rajpal. And Yanlin Wan. Say your name again and the university that you're from, and then pass it along.
Hi, I'm Jessica Allen from NYU.
Hi, I'm Vera Bykova from Higher School of Economics, Moscow.
Hi, I'm Igor Kirillov from Lomonosov Moscow State University, Moscow.
I am Aglaya Melnik, Moscow State represent.
I'm Yellen Wan from University of International Business and Economics of China. Thank you.
Hi, I'm Kartik Rajpal from King's College, and also Karen Odidika from King's College, who sadly can't be here.
Let me call a few more. Let's see. Let me read the list again, in case someone's not heard me. I'll go very quickly. So Yanlin Wan, are you here? Yes? Yes. Kartik Rajpal? Yes. Karen Odika? She's not here, okay. Aglaya Melnik is here. Igor Kirillov is here. Sam DeLong? Not here. Vera Bykova is here. Ayana Banerjee? Okay, you can get your photo taken as her as well. Okay. And Jessica Allen is here, right? No, yes, okay. Oops.
Okay, join me in an applause for our wonderful advocates.
Do you want to maybe slide over? Do you want to get a picture of them? Or yeah, slide over and get a good picture.
If you can open it again. And then we can have that's well, yeah. I mean, that's yeah. I understand what you're saying. That's really. And then if we could have step on the side. No, sorry. And then if you move it tighter, and you can stand like this towards me, and you other guys can use it exactly like the school push-up shot. And then squeeze together.
Close together, tight. Don't bite. Don't go too far away too fast. The last several years we've had a cash prize sponsored by Jose Manuel Alvarez Zarate called the Manuela Beltran Prize for the Best Woman Advocate from a country outside of North America and Western Europe. It's not meant to be a patronizing prize or anything. It's meant to encourage people. And the winner of that is, and you haven't got it on here for me. Ah, yes, excuse me. The winner is Yanlin Wan. So now we come to the best advocate of the preliminary rounds. In other words, for the 4 matches that you had on Friday and Saturday. And I'd like to invite one of the coaches, I believe she's a coach, to come and help us present that. Is Jolene Hansel here? Yeah. Jolene was the best advocate of the 2017 FDI Moot that we had in Boston last year. With that, I'll turn it over to you. Cheat. Everything there.
The best advocate of this competition is Grace Tran from the University of Ottawa.
Obviously, the coaching worked.
It may be no small coincidence that the best advocate in this competition has now come from the same school 2 years in a row. I see another coach up there, and he's smiling. Congratulations.
Actually, yeah, give it to her for the photo. That's good. That's good. Blue one or the black? Whichever. The black one. That's fine. Let's see. Let's get us. This goes with that. It's a Kostaboda salad bowl, and you may know that that's typical of Sweden. And I understand that some of the original uses for rare earths were coloring of glass. So we didn't give you any grassful to go with it.
Thank You're going to need this in order to get it home, okay?
Okay. Thank you so
Congratulations.
much. Thank you.
It's okay. So we come now to the last award for individual advocates, and that is for the best advocate of the final. Could I please have Igor Kirillov? Shake your hand.
Thank you.
And I give you a picture. You get a salad bowl as well. It's very helpful. Thank you. For the picture. So you can have your...
Congratulations.
And as a supplement to the
Yeah, there you go. You have a lot. You could turn in and give it to the computer.
Some history. Thank you.
Thank you.
So the next category is what we call the highest ranked teams. This is the combined written work and oral pleadings of the first 4 rounds. And can I please have Team Alvarez? The 3rd highest ranked team? recognize you, but you can still say who Team Lawful is.
What do I say? University of Ottawa. Okay, we can reveal it now. University of Ottawa.
The second highest ranked team is Team Schwebel. Still not here? Okay. Now, for the highest ranked team, I'd like to ask Philip Boras from Baker & McKenzie to come forward and make the award. Baker & McKenzie has been kind enough for the last 10 years, I think, to sponsor a cash prize for the highest ranked team. Like to say something, Philip?
Thank you very much. We're proud to do this from the beginning, and we do this because it is so impressive. What I have seen, I would put all of you straight into a real hearing room. Actually, I would actually wish that in a real hearing room, pleadings would be so to the point as they are here. This is really impressive. And we continue to do this because it is also so important, as in the past years, we have seen such a backlash against investment protection and investment arbitration. And you will be the next generation of the advocates, but also policymakers. And you will be not only advocates for your clients, but also advocates for investment protection. And as we heard from Tim today, this is about peacefully resolving disputes which would otherwise be resolved by ways of diplomacy or conflict. Thank you so much for doing this, and we're really proud to be part of this and to present this prize, which all of you have deserved, but the one team today in front of all of you is the VB National University of Juridical Sciences.
So now we're coming to the matches from today and the first matches of this morning, which were for the 5th place teams. I'm going to ask both teams that were in each of those 2 matches to come forward, so all 4 teams. Please come forward. National University of Singapore. UIBE. Strathmore University. And the Higher School of Economics. Let Tim give them the 5. because we haven't said who's fifth. No, you can come up. I want Professor Gibson to wait. Come up, all of you. Please come all up. It makes a nice picture on the stage. So, the two fifth-place teams are Higher School of Economics and National University Singapore. Now, it's going to be a big challenge for the photographer. We lost him. Oh. Squeeze together already for him. Get really close together. Too many. Yes, they are. Do you want to have separate shots? Maybe you can do like, is it each so teams one by one down and a shot of them. Okay, so like, please, Strathmore, please come and line up there on the staircase and get a shot. Yeah. So. Oh, this is just you all alone. Please. Line up. Try lining up on the stair. It gives a little bit of depth to the shot. Yeah, maybe one on each step. One on each step.
You could become a photographer.
Perfect.
Yeah, that's something like
Excellent. And while we're taking the last photograph, let me ask the two teams from the third place match to come down. That's MGIMO and University of Ottawa. Yeah, and either Tim or Leah will stand in for Lauren. Are they signing it? They need to sign it, the final one. They've already done that. Okay, they've already done that. So, the winner of the third place match is University of Ottawa. Tim did. And now I'd like to ask, this is the end now. I'd like to ask our tribunal from the final to come forward. And perhaps I think Lauren had to leave, so either Leah or Tim, you could join them. Or both. And may I please have the two teams from the final? So, we're going to let the tribunal announce the winner. And I will, who is in, are you standing in for Lauren?
I'm standing for Lauren, so I...
So we're not starting with 3 and 4?
We did 3 and 4.
Right, we did. I'm sorry, yes.
Should we announce the second place first?
No.
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 I've done that so many times, I've learned.
Okay. Okay, so I do this. Already? Okay. In a very difficult choice, the winner is Moscow State University.
One last secret to reveal. The runner-up was the University of Montevideo. And I should note that it was their first participation in the FDI Moot, and I hope not the last. There's something to, one step further to go, right? Okay, well, with that, I think one last round of applause for all of ourselves. And with that, I think we can go and have some refreshments upstairs again. Thank you very much. We'll get you a new one. We got it, something spilled on it and it tarnished, so we'll organize a new one for you. One last organizational announcement. Any teams ranked 17 to 53 who have not picked up their certificates can do so now.
Right here.